active IP support, focusing on regions with active IP issues. We were originally established in 2003 under the name Coie New York IP Desk and operated in New York for the past decade. Now we are a part of KOIPA, an agency under the January 1st, 2024, following a comprehensive reorganization. KOIPA transformed IP Desk covering 11 countries into wide regional IP centers and extended the existing program to cover 32 countries. Currently, IP centers have been installed and operating in 10 locations in China, Thailand, Vietnam, and the United States, Germany, Japan, and Japan. Each IP desk in the U.S. provides IP guidance for Korean small and mid-sized companies to enter the U.S. market, expand their business, and strengthen their competitiveness. 저희가 지금 원래 코트라 안에 이제 부서로 존재했었고 코트라 유용 유형과가 안에 있죠. 근데 국토청의 여러 가지 의지랑 코트라에서 원하는 방향이 조금 충돌되는 부분이 있어서 저희가 문서 나오게 됐고요. 그래서 아예 이제 완전히 특정 하나의 지식재산보호원이라 들어가면서 원래는 11개 나라만 커버했는데 지금 이제 30개 나라까지 커버하는 방송 IP센터로 많이 바뀌었고 저희는 이제 미국 본부를 관할하고 있는데요. 그 미국 본부 자체랑 중부의 시카고까지 있는 저희 이제 관할이고 여기 동부센터라고 여기는 미국 서부부터 캐나다까지 관할하고 있습니다. KOIPA's U.S. Capital IP Center is located in Texas near Washington, the nation's capital. New York IP Desk serves the needs of companies in and around the city. But starting from January 2024, KOIPA's U.S. Capital IP Center covers the entire eastern United States, including Boston, D.C., Atlanta, and Chicago. We welcome Korean small and mid-sized businesses seeking IP rights. 저희 이제 타이슨스의 오피스 아직 연관 아니고요. 지금 여기서 한 10분 정도 차 타고 가면은 그 힐튼 미국 전체 힐튼 헤드쿼터가 있거든요. 거기 바로 앞에 새로 오피스를 4월 1일에 열게 됩니다. 관심 있으신 분들은 방문해 주시면 좋겠습니다. Last year was our 10-year anniversary. Over the past decade, we have strived tirelessly to provide important information and unparalleled service regarding IP rights. It's really great pride that we reflect on our accomplishments, and we look forward to continuing our mission with the same vigor and enthusiasm in the years to come as KOIPA's U.S. Capital IP Center. The KOIPA's U.S. Capital IP Center works in a variety of ways to achieve its mission. KOIPA's U.S. Capital IP Center's services can be broadly divided into 3 different categories. First, assistance with IP rights. IP Center provides assistance regarding the acquisition and protection of U.S. IP rights. We also provide initial response guidelines for businesses that have been sued or received a court summons in the U.S. 저희가 이제 크게 보면은 3가지 정도로 일을 나눠볼 수 있는데 첫 번째는 미국에서 예를 들면은 소장을 받으셨거나 IP 이슈 관련해서 무슨 분쟁이 생겨서 어려움 겪으시면은 저희가 가장 처음에 이제 이걸 어떻게 대응해야 될지 가이드라인을 제시하는 역할을 하거든요. 그게 이제 첫 번째 역할이고요. Second, information services. IP Center actively educate the public about U.S. IP laws through seminars and other various channels of communication. We collect up-to-date information regarding current U.S. IP litigation trends to help prevent and avoid potential conflicts. IPcen터 monitors national and international industries and related patent activity to identify and predict potentially problematic patents and to provide early warnings for potential conflicts. We create databases of U.S. attorneys and provide them to Korean businesses that may need access to such information. 그 두 번째로는 저희가 이제 오늘처럼 이제 세미나를 많이 개최하고요. 그리고 크고 작은 세미나를 개최하고 또 뉴스레터를 매달 발간하고 그다음에 이제 미국에서 IP 분쟁에 관련돼서 최신 뉴스를 이제 2주에 한 번씩 저희 웹사이트에 올리거든요. 그래서 그런 역할을 두 번째로 하고 있고요. Lastly, subsidizing IP application fees and costs. IPcen터 provides subsidies for patent and trademark applications and legal opinion letters. Our patent and trademark application subsidizing program offers 50% of attorney's fee for small companies, small and mid-sized companies, and up to $2,500 per patent case, $1,500 per design patent case, and $700 per trademark case, with a maximum of 10 cases per year per company. One company can receive the subsidizing fund up to $5,000 per year. Only an individual, small or medium-sized company registered as a business in South Korea that operates or plans to operate a business in the US can apply to this program. 저희가 하는 프로그램 중에 조금 세 번째로 하는 일은 정부 보조금을 지원해주는 프로그램을 운영하고 있거든요. 그래서 실용 특허 같은 경우에는 하나당 2,500불까지, 그다음에 디자인 특허는 1,500불, 상표는 700불까지 각 어플리케이션당 지원을 하고 있고요. 그리고 중소기업, 중견기업 모두 50%, 그다음에 1년에 10개까지 어플라이 할 수 있고요. 지원받을 수 있는 금액은 맥시멈이 5,000불입니다. 그리고 이게 지금 패턴 앤 트레이드마크 어플리케이션스는 이렇게 되고, 그 다음에 리걸 오피니언 레터스라고 해서 이제 조금 분쟁에 가까워진 상황 있잖아요. 뭐 경고장을 받았다든지 아니면은 IP 분쟁에 가까워진 상황에서는 저희가 FTO 그러니까 경고장에 대응하는 리걸 오피니언도 레터를 써드리고, 그 다음에 또 FTO도 하고 NDA도 하고 이런, 그러니까 되게 다양한 종류의 IP 분쟁 관련한 문서들을 지원하는 프로그램도 운영하고 있고요. 이 경우에는 제가 원래 영어를 먼저 해야 되는데 이 두 번째 거는 한국말 먼저 할게요. 이 법률 의견서 지원 사업은 중소기업은 70%, 그다음에 중견기업 50%까지 변호사 비용이 보조가 되고, 그다음에 한 케이스당 10,000불까지, 그다음에 한 해에 한 컴퍼니당 2건까지 이제 지원 가능합니다. So IPcen터 also provides subsidies for legal opinion letters. The legal opinion letter program provides subsidies for conducting patent infringement analysis, which as we call freedom to operate, reviewing non-disclosure agreements, and drafting legal memorandums responding to legal disputes related to IP with a specific focus on the pre-litigation stage. We provide strategic advice and support to Korean small and mid-sized companies before legal disputes escalate to the full-blown litigation stage. Our legal opinion letters program offers 70% of attorney's fee for small companies and 50% for mid-sized companies up to $10,000 per case, with a maximum of 2 cases per year per company. Only an individual, small medium-sized company registered as a business in South Korea that operates or plans to operate a business in the US can apply to this program. 그 지금 말씀드린 두 프로그램은 다 한국에 이제 사업자 등록이 되어 있어야지만 어플라이 할 수 있고요. 중소 중견기업 개인 이렇게 어플라이 할 수 있고, 그다음에 또 미국에 이제 수출 예정이거나 수출을 이미 하고 있는 경우가 조금 유리하게 판단이 되고 있습니다. 저희 심사를 거쳐서 선정을 하고요. 그다음에 Every year, KOIPA and KIPO attend various trade shows and seminars where we counsel companies on how to best protect their IP rights, including patents, trademarks, and copyrights at the event. 저희가 코트라 안에 있을 때도 그렇고 여러 가지 이제 트레이드 쇼나 어떤 전시회에 이렇게 파견을 가가지고 상담해주는 역할을 하고 있습니다. We also offer these services online, especially during pandemic, which was very well received as many companies were able to participate regardless of their location. We still host frequent webinars, and twice a year we hold a legal business consultation program where we bring in experts in their respective fields to provide free 30-minute consultation to companies. 저희 그리고 이제 온라인으로도 상담회를 많이 개최하고 있고, 저희 1년에 2번 그 변호사님들 모시고 무료로 30분씩만 상담할 수 있는 그런 기회를 이제 제공하고 있거든요. 그래서 저희 IP뿐만 아니라 뭐 FDA 쪽도 많이 이제 상담하고, 그다음에 많은 분들이 관심 있으시더라고요. 관세, 그다음에 FDA, IP 이렇게 세 분 모셔서 보통 많이 하고 있습니다. We also created a virtual IP consulting center at Gather, a Korean metaverse tech company, so that Korean small and mid-sized companies can go online and get IP advice whenever they want. 저희가 이제 상시로 이 지식재산권 상담소를 온라인으로 겟더에다가 설치를 해놔서 필요한 분들께 예약을 받아서 항상 상시 상담을 하고 있습니다. The photo on the left shows a webinar on the latest developments in the U.S. IP law and policy that we hosted in August 2021 during the height of the coronavirus pandemic with speakers Andrei Iancu, former U.S. Undersecretary of Commerce for Intellectual Property and Commissioner of the Patent and Trademark Office, and Vincent Garlock, Director of the AIPLA, providing in-depth discussions. We also have a YouTube channel. So 지금 라이브로 유튜브로 나가고 있고요. The U.S. Capital IP Center's YouTube channel provides a basic but practical overview of U.S. patent and trademark law and features many of our past seminars and webinars. 저희가 그동안 했던 많은 세미나, 웨비나들이 이미 저희 여기 이제 아직은 코트라라는 이름이랑 같이 이제 쓰고 있는데 저희 유튜브 채널에 올라와 있습니다. 그래서 한번 보시면 많은 도움이 될 것 같습니다. 저희 이제 세미나 했던 장면들 많이 찍었고요. These are some of the seminars that when we were new IP desk. In addition to large-scale seminars with more than 100 participants, the New York IP desk organized smaller seminars as well. 그래서 작은 세미나도 많이 하고 있고, 근데 저희가 뉴스레터가 이제 한 달에 한 번씩 이렇게 발간이 되는데 저희 나갔던 뉴스레터들이고요. Each month we update its newsletter subscribers with the latest IP trends rotating through topics of interest to businesses such as patent, trademarks, copyrights, and trade secrets. We collect all the newsletters sent out each month and publish them in a book at the end of the year. In addition to our annual newsletter compilation, we often publish books covering subjects ranging from the latest developments in the U.S. IP policy to IP topics of interest to East Coast U.S. startups. 그래서 저희 이제 프로그램들 다 모아놓은 여기 이렇게 리플렛이 있는데 밖에다 뒀으니까 한 번씩 봐주시면 좋을 것 같고요. 그리고 IP 뉴스레터를 이제 1년치를 다 모아서 책으로 내기도 하고, 여기 보면 이제 스타트업들한테 유용한 정보들을 IP뿐만 아니라 전체적으로 다 모아서 책으로 내기도 했습니다. The Patent and Trademark Applications and Legal Opinion Letter Drafting Subsidizing Program is announced on KOIPA's website on a rolling basis. This year, the program will run 4 times in total, and the first round of the program is closed just yesterday. It has been great to see companies effectively resolve their legal disputes through the U.S. Capital IP Centers, Patent and Trademark Applications and Legal Opinion Letter Drafting Subsidizing Program. 그 저희가 이제 1년에 4번 그 지원 프로그램을 운영하고 있고요. 이렇게 밖에 공고문도 자세히 좀 보시려면은 제가 말씀을 다 드렸지만 그 공고문도 뽑아서 뒀으니까 한번 보시면 좋을 것 같고, 1년에 4번 하는데 요 첫 번째 이제 1차는 어저께 끝났어요. 그래서 혹시 관심 있으시면은 지원해 주시면은 지원 준비해 주시면 감사하겠습니다. 아마 저희가 4월 말에 2차 이제 프로그램 운영될 예정입니다. So KOIPA's U.S. Capital IP Center is the first contact point reached out by Korean companies in need of help on their IP matters, and will serve as a bridgehead for Korean companies seeking to acquire and protect their IP rights in the U.S. We are committed to providing our best efforts in helping Korean business with their IP journey. Please reach out to us if you have any IP needs. Thank you.
Thank you, Ms. Kim. By the way, if you need a Wi-Fi connection, you can connect to KUSCO conference, and the password is KUSCO, K-U-S-C-O in capital K, 330. Next, we'll have a congratulatory remark by IP counselor Tan. 다음은 한만늘 특허원님께서 축하 말씀 해주시죠.
네, 안녕하세요. 신인 특허관 한만일입니다. 만나 뵙게 되어서 반갑습니다. Good evening, ladies and gentlemen. I'm very grateful to have this opportunity to extend my congratulations on this occasion. This forum marks the first joint event between the Korean-American patent attorneys and the Korean-American scientists and engineers in Washington, D.C. area. I think science and technology intricately relate to patents. When scientific research lead to the new technology, then patents are the best way to protect them. So after securing rights, then new technology could be successfully turned into new product, and the resulting revenue can be reinvested to the further R&D. So this is the cyclical structure of the innovation. So on a global scale, Korea and the United States are closely entwined in this cycle. The United States excelled in the scientific and technology, and while Korea has some strength in manufacturing. So American scientific advancement are sometimes being transferred into the can be transformed into products in Korea's factories and then distributed worldwide. However, in this process, the risk of technology theft and sometimes of patent infringement poses severe challenges for the companies. So it is my opinion that there is this is where the Korean American patent attorneys or scientists or engineers or in their community can play a big role in preventing such incidents. And today in this forum, so it is my understanding that many researchers, engineers, and students in biotechnology field are attending today. So the importance of patent in biotechnology or pharmaceuticals or some chemistry cannot be overstated. The fact that the first US patent was related to chemistry, so which was the process of making potassium used in fertilizer, is the testament of this importance. And the various patent systems such as patent linkage systems or patent term extensions originated from this field. So in this sense, today's gathering from IP and researchers will facilitate the connectivity between two fields. So, and lastly, I would like to express my sincere gratitude to KOIPA, IPCenter and KAIPBA, KSEA, and NIH-KWiSE for organizing today's event. And additionally, as I am a patent attorney, so please feel free to reach out to me if you have any concerns about Korean IP, something like that. So I hope today's event proved to be informative and enriching for all of you. So 아무 특허 관련해서 어떤 의견이 있으면 연락 주시면 감사합니다. 감사합니다. Thank you very much.
Hi everyone, I'm Alex Chung. Thanks for this opportunity to present my personal view on the broad functional claims given the current status of the US case law. So just a simple disclaimer that this is my personal view, not my firm's view. Obligatory disclaimer. So I'm going to present today focusing on this one very prominent case that came down from the US Supreme Court last May of 2023, called MG v. Sanofi case. I decided to focus on this single case, though I talking about the general functional broad claims. This particular case really manifests all the current thinking from the judiciary about the broad and functional claims and sets out a lot of boundaries and uncertainty on the functional broad claims. So this would be one single case that we need to understand fully to be able to really try to make some strategy about how to claim the best and efficient way and avoiding the risk of the invalidating of the claims given the current status of the case. So the engine Sanofi case is about the antibody technology generally. And there are some conventional claims that Amgen obtained based on the conventional method of claiming the antibody, based on the CDR, which is the complementary determining region. So I'm going to be just presenting this more standard antibody claim that Amgen obtained first. So in 2011, Amgen actually obtained this very structure-based, CDR-based conventional antibody claims. And the claim was covering this drug called Rofatha by Amgen. That is basically the cholesterol-lowering antibody therapy, and the antibody is targeting and binding to a protein called the PCSK9. Shows here is a long name, but I'm going to just say PCSK9 going forward. So what it does is actually the PCSK9 binds to this another receptor called the LDL receptor, and that LDL receptor's role is in the nature that kind of binds and removes the naturally occurring LDL, the bad cholesterol. So basically, the LDL receptor is essentially in lowering the bad cholesterol in the bloodstream. So when the PCSK9 binds and degrades the LDL receptor, LDL cannot be anymore absorbed from the bloodstream through the receptor. So by blocking that PCSK9 with antibody, the end result would be actually allowing the LDL receptor to bind the LDL and remove it from the bloodstream and eventually lower the bad cholesterol from the blood. So that's how it works. And naturally, the essential goal was just to block and bind and block the LDL receptor by PCSK9, by the PCSK9 targeting antibody. And then the more conventional way of obtaining the antibody claim was based on these 6 CDR sequences, as you can see from this claim one here. We have this PCSK9 binding antibody comprising certain sequence of the CDRs. So if you look at the first top, heavy chain polypeptide is comprising CDR1 and CDR2 and CDR3, and the same way goes for the right chain polypeptide, CDR1, 2, 3. So in total, they have the 6 CDR binding motifs that actually determines the binding of the antibody towards the target protein PCSK9 here. And then the program was actually another claim that they obtained a few years later in 2014. So in 2014, Amgen also obtained 2 additional continuation patents, 165 and 741, and the claim was very broad compared to the claim that you just saw. And the claim was kind of claimed in such a way that it's functionally defining the antibody rather than actually looking at the sequence of the antibody. So that became the issue because Amgen actually asserted this particular broad claim against Sanofi. And Sanofi wanted to invalidate Amgen's patent, and there came a lot of series of low court and higher court cases, which ended up going to the Supreme Court. And that's the case that we are looking at now. And generally, you can say that this broad claim is really covering the entire genus as opposed to the species. So when we talk about the genus and species in patent law, genus is more bigger class comprising the small species within the genus. So the kind of characteristics of these patents from Amgen was that these monoclonal antibodies are covering the entire genus that could bind and block the PCSK9 protein. And according to the Federal Circuit's expression, it was kind of double function claims because they actually showed two functions in one claim, binding and blocking. So let me show you what that means actually here in one exemplary claim. So in claim 1, if you can see these claim languages, it looks a little bit complicated, but actually it focuses on those 15 amino acid residues, that they call sweet spot. So what they mean by that is when you have these 15 amino acids, that kind of determines the binding of the antibody against the PCSK9. So this is in more technical term called epitope of the antigen. So epitope is the particular amino acid sequence of the antigen that determines the binding of the antibody towards the particular antigen. So in this case, those 15 amino acids on the surface of the PCSK9 protein is what determines the binding of the antibody towards PCSK9 target protein. And if you can look at the languages here, the claim language focuses on 2 functions, binding to those epitopes or sweet spots, and then thereby blocking the binding of this PCSK9 protein to the LDL receptor. So the claim is directed in such a way that it defines this whole series of protein antibodies that could bind and block the target protein, and focusing on only those 15 amino acid epitope sequences. And the remainder of the same pattern or other patterns that was an issue in the case follow the same track. Basically, if you just focus on the red fonts, it binds to 2 of the sweet spots, and also in claim 29, binds to at least 2 of the residues again, and then blocking the binding of the PCSK9 area. So the same way. Follows the same trend in other patterns, binding the epitope in this case. Also neutralizing antibody. Neutralizing antibody means it's blocking the binding of the target protein to its own target. So basically it's neutralizing in such a way that the PCSK9 protein cannot bind to the target protein LDL receptor. So in this fashion, the engine's pattern was pretty functionally broad and supposedly covering a lot of species. But on the other hand, the disclosure of the specification in engine's pattern was not really sufficient. That was the decision by the Supreme Court. So let me briefly go through what was disclosed in the specification of the engine pattern. So since we have these two patents at issue, I'm going to focus on the common features of those two patents. And in those two patents, the disclosure was really focused on 26 antibodies as an example. So they had these exemplary embodiments of 26 antibodies, including the sequence and all the CDRs included of those 26 antibodies. And also there are some 3D structures of antibodies. Those two antibodies disclosed in those two patents, as shown in this lower panel. So if you look at this, this is pretty impressive data set, actually 26 antibody sequence and two three-dimensional structures. Also, there are some other methodology disclosed, depending on how you look at this. This could be really guiding post of discovering antibodies. So what Amgen called as roadmap is the sequence of the testing and screening procedure for making and identifying the desired antibody from the core. So basically, if you look at the sequence, it's pretty commonsensical in the sense that it's just generating antibody and testing whether it's binding to the target, whether it has binding ability to the target sweet spot, and also have the ability to block the function of the target protein. So it's kind of mirroring the exact sequence of the claimed functions. And also there are second part of conservative substitution. So what it means is basically you just have this one known antibody and you are kind of swapping off one amino acid into some other amino acid and see whether that changes the function. So essentially it's kind of directing you to go through the same procedure that's in the roadmap portion to be able to see whether any kind of modified antibody sequence is still giving rise to the same ability of binding and blocking. So if you take a look at this and think about the whole procedure, it's kind of guidepost for some procedures that you need to actually go through anyway to identify any antibody that's binding and blocking. So in the end, this roadmap or the conservative substitution was not really enough for the enablement. That was the final decision by the Supreme Court. So if you look at the enablement requirement in the statute, it says it enables any person skilled in the art to make and use the same invention. So basically it's requiring you to disclose enough information and guidance to the person skilled in the art, in this case maybe researchers in the antibody technologies, to be able to look at your specification and pattern and follow the direction and guideposts and be able to find the exact antibody that you are claiming in the claim. So I'm going to skip this, actually this is the legal standards. So for these Supreme Court cases, there are kind of two schools of thoughts on the whole case. So one school, on one hand, thought if you allow this kind of broad genus claim, it's going to incentivize the investment. So they basically thought this broad genus claim is very good for the environment and investment opportunities. Because you have this broad spanning coverage, and VCs would be preferring this kind of coverage to be able to invest their money and get recoup the investment later. So there was some supporting parties in addition to engine on this same school, FE, GSK, broad, etc. And then the other side was actually Sanofi's side, which is saying the broad spanning the genus claim is really bad for the innovation because you are kind of blocking out the whole area by having this claim covering the whole genus and whole function. So there were a lot of debate about this over the 2 to 3 years, a lot of amicus briefs and commentaries and legal theories, etc. And then the decision came down last May, unanimous decision, and saying this is not allowed. Engine patents, those two patents got invalidated based on the enablement requirement not being met. So this is a little bit kind of legal policy issue. So generally what we are looking for is some kind of give and take. So when you provide the protection in terms of the patent for 20 years, you are actually expecting to have some kind of disclosure to the public on the technology. So basically under that kind of quid pro quo or give or take kind of policy view, the engine patent didn't provide enough sufficient disclosure to be able to justify the breadth of the scope of the claim. So according to the Supreme Court's decision, the engine patent claim was just covering the whole entire class, and that was not really sufficiently disclosed by the spec on the other hand. So as you can see here, we have this kind of quote from the Supreme Court, kind of putting the specification and the claim on the equation. Basically, they're comparing the scope of the claim and the disclosure of the specification and seeing whether that was sufficient enough. And the really rule of thumb is, as I quoted here, the more one claims, the more one should enable. And especially when it comes to the Janice claim, not just the particular antibodies, this is really important kind of measurement to be referenced against. And the whole opinion really emphasized the functional Janice claim is not really anything different from the regular enablement standard. They're just using the same standard that's been used for the last 100 years, but under that same standard, the disclosure was not sufficient for the claim scope. So they ended up citing this like 100-year-old cases from 1854. This is the Morse code pattern. I'm not going to go through all the details, just giving you some sense of what we are talking about. Second one is Edison's light bulb pattern. And third one is from 1928 about some glue or starch glue. So basically what they just was comparing is, given the case law spanning over 100 years, the standard has been the same. Basically when you claim a lot more, you gotta disclose a lot more. So this is a quote from the oral argument at the Supreme Court. And the whole discussion between the Supreme Court justice, and the defending lawyers are really focused on the size of the class that you're claiming, and also versus the extent of the disclosure from your specification. That's the key comparison point here. So I'm not going to go through this whole thing, but basically the justice is just asking about, okay, in your work, how many species are you talking about in your claim? And the second part is about the government side. So this is the Solicitor General's argument, saying that this is not really good for the innovation in the whole field. When you have this very broad and functional Janice claim, that's blocking innovation in the whole field. It's more policy view from the government. So this inquiry into the enablement is really defined by this key case called In Li Wan's from 1988 Federal Circuit case. So I'm not going to go through all the details here, but I'm just citing this case to show that traditionally we are going through all these 8 different elements to be able to see whether some claims are really enabled or if it's kind of requiring some undue experimentation. So when you say undue experimentation, so you need to go through a lot of experimentation and trial and error to be able to really get to the claimed species. When that's the case, the claim is too broad and not really enabled by the disclosure. So to be able to see whether that's passing the test of undue experimentation, you go through these 8 elements or factors. So as I highlighted here in red, there are some key keywords that you kind of look at the case and find it very often. It's the breadth of the claims and predictability in the art itself, and the direction or guidance by the spec or inventor or examples, or the degree of the or quantity of the experimentation needed. So basically you're just kind of balancing all these different factors and see whether there's just undue or due experimentation to be able to get to the whole class of the invention. And in this case, engine case, the problem was, according to Supreme Court's mind, this was monopoly on the whole antibody class, because the size of the genus that was claimed in the claim that we just saw was really in dispute between two parties. So Amgen told Supreme Court it is just few hundreds, versus in Sanofi's view it was millions. Because the antibody, again, if you refresh your memory about the claims that it said, it's just binding to these 15 amino acid epitopes. And any antibody that binds to those epitopes and block the function of the PCSK9 could be claimed, included in the claim itself. And in Amgen's view, it was just few hundreds, but Sanofi says it's more than millions. And also the disclosure itself, as opposed to this very broad antibody claim scope, the disclosure was not really sufficient to cover all those millions of candidates, because you have just 26 antibody sequence and 2 3-dimensional structures. That's not going to be enough to cover the millions of candidates. And this is really interesting part of the litigation. So sometimes you bring in the experts to support your own argument, and in this case, Sanofi brought in Sir Gregory Paul Winter, 2018 Nobel laureate in antibody field. He's like the godfather of antibodies, and he said there is no way one can see one antibody binding some target and predict whether it can also block the function at the same time. And if you remember, the claim was dual function, binding and blocking, and this Nobel laureate is saying, okay, whenever you have some antibody binding some target, you cannot say whether it's going to be actually blocking the function. So there's this huge unpredictability and uncertainty in that statement. Right? And then also another Amgen expert actually acknowledged that you cannot really look at the sequence of the antibody and predict the 3-dimensional structure. So somehow this Amgen expert actually stated to the contrary of their own party's assertion that sequence is not sufficient to predict a function, essentially. So basically, I can maybe skip this. The Supreme Court saw this Amgen assertion as being just too greedy and too far-reaching compared to the disclosure that they had in the specification. So this kind of quote of the Supreme Court decision is actually pretty important here. So on the second point here, research assignment or trial and error method. So that's what really took up the whole Amgen argument. Basically, they are saying these guide lab or guide posts that Amgen asserts is sufficient. It's just research assignment or trial and error method. So you are still supposed to just follow this guidance and try out so many different things to be able to find the particular antibody that binds and blocks the function as claimed. So in other words, actually, it was almost like a hunting license. So it was not complete enablement, but just the hunting license to really go out and search for the antibodies that fall within the functional claim. So I'm going to skip this part here. Okay. And this is not all just domain to loom, because I'm saying this because so far this looks like, okay, you cannot really plan anything functionally or broadly. But it's not that like stark prohibition on claims. So there are some boundaries or some carve-outs that Supreme Court kind of indicated that you are not really expecting you to describe every single embodiment of species in the class. It's not that high standard, but you are supposed to have some kind of general quality running through the whole class. So what that means is, if you have some kind of common features or common maybe structural formula or some chemical formula that can actually represent the whole class, then you'll be fine. Then that should be enough to enable the whole class. But as you can think of, if you are coming from the science background, you understand this is pretty tough, especially in the antibody space. Because you cannot really have some formula that can really allow you to predict all the binding or blocking ability of the antibody. And also, they are not really asking you to avoid complete experimentation. So as long as the experimentation part is not really undue, and as long as there's just some reasonable degree of experimentation, that should be fine. So basically, the bottom line of this case is you gotta really focus on the scope of the claims, and you shouldn't really try to monopolize the whole class or Janice. And also, the whole technological area's predictability. That's the other equation of the balance. So if you have a really broad claim, you're going to have this very predictable technology area. Otherwise, you are just claiming too much in view of the predictability of the whole technical areas. So when you have a more predictable art, for example, chemistry or small molecule, compared to antibody or cells, then you are more likely to have a less high standard, because it's a little bit more predictable than antibody or cells. And the guidance in the specification cannot be just asking you to go and try and go for trial and error. There are going to be some more firm guidance other than trial and error. So bottom line here, this is antibody case as you saw. The experts in this industry is looking at this case and saying this is not going to be just limited to the antibody or even biology case. It's going to go over the life science area and maybe affect other areas like software or even AI patents, because the general framework of this species versus genus is all present in all those different arts. So it could be really far-reaching effects in other technical areas other than life science. As what happened in the Section 101 case, maybe that's going to be covered by Janice today to me. In the media case or CS bank case, those cases were in really different areas than life science that still end up affecting all of the life science patents. So we are expecting some kind of ripple effect basically in all industries. So the fear is actually this is spilling over some other Section 112 written description case, because I didn't have really chance to cover this case yet, but there was this prominent federal circuit case in 2021, Genovi case. But this case was not really taken up by the Supreme Court yet. So this another Section 112 requirement called written description is still kind of pending almost. But this engine Supreme Court case is really close enough that maybe it may be affecting the future written description case and maybe skew the balance still further against the patents in the same. So I'm going to skip this a little bit then. One scrubble thought is actually, since this is antibody case, there are a lot of unpredictability obviously. But when it comes to the RNAi or antisense case, there are more predictability, because once you know the sequence, you can predict the target based on the sequence of the RNA or RNAi. So people are thinking maybe in those areas, even though they are biologics, there might be a little bit less stringent standard compared to this engine case. And also, as you can see from this daily news, sometimes you see this machine learning or the AI tools can be able to that they can really predict the three-dimensional structure of the antibody or proteins easily. So you could maybe predict some functional aspect of the proteins based on those development in the AI area in the near future. So the predictability of the whole technology may be changing, and maybe it's lowering the standard of this predictability in the near future. But this to be seen. Yeah. So I'm gonna skip this. In more practical tips, actually, when you try to obtain the patents, there are some aspects you need to consider. So, as you can see, if you have too much scope in the claim, you may lose your whole patent, essentially. Okay? So you gotta really try to find as much as possible data set and the guidance of the discovery methodology, and also try to find maybe some common features or qualities, as I mentioned before. So some common motifs or sequences or structural motifs or features that you can maybe claim tied to the whole genus of the claim. And also it's best to just try to provide all of the many examples and species as much as possible, and detailed guidance. And also in terms of the portfolio strategy, you may have to maybe chop it up to different applications. Rather than just trying to claim the whole genus, you maybe wanna chop it down to different continuation or divisional applications, such that each application has just one aspect of the invention. So essentially, you are trying to claim the whole territory by small cities or even states rather than the whole continent. And obviously it's going to cost a lot of money because you are thinking about maybe 10, 20 different applications as opposed to few just broad claims. But it may be actually hedging against the risk of losing the whole genus or functional claim set as opposed to just one species of claim. So that may be one strategy to think about, and also maybe reissuing patents to broad scope to be able to maybe narrow it down to very specific scope compared to your data set. So there are a lot of considerations to think about how to strengthen your portfolio going forward. And also in terms of the enforcement strategy, litigation strategy, we have this kind of little bit of good news for the potential infringer, because when you are trying to look at the potential risk of infringing other patents, you don't have to really take the broad spanning functional claim as is. It may have some risk of being invalidated. So when you identify some broad spanning genus claim or freedom to operate research, you may not get worried too much as much as before, because those claims could be invalidated in this new regime. So on the other side, actually, if you are a patent holder, on the other hand, you may expect to get some challenge or invalidation attack on your patent based on the non-enablement argument. So based on that, we gotta try to find maybe the most narrowest and also specific claims in your portfolio, or maybe intentionally make an application covering those very specific aspects of invention, so that it withstand the invalidation challenge and also be able to assert the very specific claim without the risk of being invalidated in the litigation. So actually, after this this decision came out in May of last year, there has been already few litigations being held against the big pharma or biotechs using the argument from the Amgen Johnson case already. And in my recent research, actually, there has been more than a few dozen cases currently pending based on the Amgen Johnson case. Yeah, so this is the wrap up for my legal side, and quickly I'm going to go through my career track. We are going to have this second from of the career consultation here. So I went from the science side to law side, and this is kind of split up between science and law prior to 2009 and after 2009. So I was in different disciplines in different research areas throughout both bachelor and master's and PhD, including postdoctoral research time. And I went through all different immunology, neuroscience, biotechnology, etc., gene therapy, through my own interest. And turns out those interested areas became kind of hot area these days in technology. So I'm kind of fortunate in the sense that I'm kind of already versed in those very popular technological areas in the life science. And then I switched from science to law in 2009, going to GW Law School. And the big motivation was actually, even though I didn't say it here, during my PhD in neuroscience, I actually got a US patent under my own name as an inventor, and then got licensed out to in vitro background. It is now part of Thermo Fisher. So I may be one of the few technologists actually who's getting the patients from Thermo Fisher. As a small personal reminder for my invention. And then from JD, from GW Law School, I went to different law firms of different sizes, IT boutiques, including Stone Castle, and Henderson, and big law firm, including Johnston and Perkins from now. I've been dealing with a lot of different cases, as you can see here. I just put down some names of the cases that I can disclose at this point. So I've been doing a lot of prosecution counseling and litigation at the same time. And maybe one of the latest cases that I was involved in was the SK Innovation case on lithium-ion battery against the LG Chemical. So that was kind of big publicity in Korean media a few years ago. I was involved in that case too. Yeah, so thanks so much for your attention, and I'd like to answer any question about the case or my career. Here, what I have to know. Thank you. Do we have enough time for Q&A now, or should I do it later?
Because we have just one question.
Okay.
DNA sequence, right?
Yeah, right.
So I'm assuming from the time that they cause pattern of DNA sequence, you did probably more work and experiment to understand pharmacodynamics, and then that's whatever the discovery. So you couldn't sort of disclose more in the continuations that would have made it more difficult to challenge that?
Yeah, good question. So by definition, the continuation or division of pattern is based on the same specification. So it's just following the exact same disclosure as your parent application. You cannot add any new matter. The moment you do that, actually it becomes the continuation in part application rather than continuation. So continuation application is by definition having the same disclosure. So even if you have new data, you cannot really just include it there because by definition you are not really having the continuation application if you add any new matter. So the moment you do that, you have this later priority data set on the time of the addition of the new data set. So that's why people are trying to use continuation or divisional as opposed to continuation in part. So maybe one strategy might have been just finding another pattern family, totally different family to be with newer data set, and maybe claiming this broader claim in that new family. Then may have been the strategy. Thank you.
안녕하세요. 모건 루이스 DC 오피스의 제니스 로건이라고 하고요. 특허 변호사가 된 지는 이러면 나이를 아시게 되니까 별로 얘기하고 싶지 않은데 특허 일을 한 지 한 14년 넘었고요. 그리고 오늘 제가 발표할 주제는 Patentable Subject Matter라는 주제로 준비해왔습니다. So I'm going to talk about the patentable subject matter. It's about 35 USC 101. And I think a lot of you may know already about this, but today I'm going to go really basic for some students who don't know anything about this. So in US, it's a very unique section because only US has so many restrictions on what can be patentable. It's not true in most of other countries, including Korea. For example, one of the famous cases is isolated or truncated DNA sequence. As you may know, in biotech, short sequence of probes can be used as probes. In a long sequence of DNA, you cut out a short sequence and use it as a probe sometimes. But the short sequence doesn't exist in the nature. But U.S. Supreme Court has decided that yes, even if it's truncated, it does exist in nature and it's not patentable. And that decision was a big deal because only U.S. and Australia prohibit protecting isolated sequences. So examples like that continues. So I believe, I just learned today that we are broadcasting on YouTube about this seminar, so I need to be careful about what I talk about today. And I do need to say disclaimer that whatever I talk about today stays here, and it's only my opinion, nothing to do with Morgan Lewis. So please keep that in mind. As I mentioned, patentable subject matter is related to 35 USC 101. And I think one big difference between Korean law and US law is that US law is very short. So 35 USC 101 has only one sentence. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent therefore, It's very short, but it even has two different subjects in this one sentence. First, the invention has to be useful. So if you file patent on a random stick, wooden stick, you may get a rejection from the US Patent Office that it's not useful, utility rejection. And 101 rejection that I'm talking about today is patentable subject matter And about the patent of subject matter, this section tells us that 4 things can be patentable, which are process, machine, manufacture, and composition of matter. If the matter was this simple, it would not have been a problem. But other than these 4 allowable patentable subject matter, Supreme Court has decided there are judicial exceptions, including laws of nature, natural phenomena, and abstract ideas. These 3 are judicial exceptions determined by the Supreme Court, and it was never written into the law. So we call it judicial exception. So there are 3 judicial exceptions. First one is law of nature, like naturally occurring correlation. For example, the famous Supreme Court case is Mayo. If you take a drug, like for example insulin, and the human body changes the level of glucose in the body, it's a natural phenomenon, right? Natural correlation. So that alone cannot be patentable. And natural phenomena or product, a natural product, yes, that's the first one is law of nature, sorry. And the second one is the natural phenomena or product, which is the truncated DNA probe that I just told you about in the beginning. And the third one is abstract idea, which includes a lot of the business methods, such as Bilski and Alice Corp, like method of exchanging obligation, human activities, and things that you can do in like E equal to mc squared is also, and the calculation, a lot of the calculation and formula are known to be abstract ideas. So as I briefly mentioned in the previous cases, previous slide, there are some significantly important Supreme Court cases. The first Bilski case about abstract idea came out in 2010, and this time none of us cared. It was about business method, and for us it was like a foreign language. I did not understand. And then 2011, the Mayo case came out, and this is the case where the correlation between the, like for example, taking the drug and having a glucose level change in the body, that's a law of nature. And you cannot patent it unless you claim something more in addition to it. And the third case was 2013 Myriad case. So Myriad case is the one that's about the truncated DNA probe. And this was like sensational. This was like the US became the first country that doesn't allow truncated isolated probes. In 2014, this surprisingly limited patentable subject matter applied to all the computer implemented technologies because of abstract ideas. So after these 4 Supreme Court cases, a lot of cases got invalidated. Everything got invalidated because it wasn't patentable subject matter anymore. There are very limited number of patent eligible claims after these Supreme Court cases. So it's similar to what Mr. John Alex presented. I think currently US is anti-patent compared to 10 years, 14 years ago when I started patent practice. It was so much easier to get a patent from USPTO. Now it's so difficult. And the law or Supreme Court has decided on written description cases, enablement cases, patentable subject matter cases, it has limited the scope of the claims that we get for patents in US. So that has been a very difficult decade for us. In a way, as a lawyer, it was very exciting because there were a lot of up and downs and changes that we got to learn a lot of new things, and we had to strategize different ways to overcome it. So anyway, so I wanted to show you this graph or diagram because this is a diagram that US Patent Office used. So every single examiner has to use it. I'm not going to comment more on that, but every single USPTO examiner has to use it. And the first step is to see whether the claim is directed to those 4 statutory categories, those 4 statutory categories that was recited in the 35 USC 101. Process, machine, manufacture, or composition of matter. You have to have at least one of these 4. Even if these 4, so exceptions to this. Like you must be wondering what kind of invention is not within these 4 statutory categories. For example, the transitory form of signal transmission, like naturally occurring organism, like human. You cannot patent human. Yes, it's not one of those 4 categories. And this is an interesting Federal Circuit case from 2015. And sadly, in this claim, they were claiming interface comprising input means, output means, and audio playback means. So they claim means to make it broad, right? So they tried to make the claim broad, but it backfired because the court has decided this was not part of any of those 4 statutory categories. So you need to be specific enough at least to include one of those 4 things. Once the examiner decides that you have at least one of those 4, they see whether the claim is directed to any of the judicial exceptions. And when they say whether the claim is directed to judicial exception, there are 2 prongs, 2 things that they say. Number 1, whether it recites any of the judicial exception. So please keep in mind when people say when the claim is directed to judicial exception, it doesn't mean that the claim simply recites the judicial exception. Direct means more than just reciting the judicial exception. Because first you have to recite the judicial exception, that has to include the judicial exception. And second, it doesn't have any additional element that integrate the judicial exception into a practical application. You must be like, what does this mean? That's just a legal standard, legal jargon. I'm not going to go into the detail. I'm going to give you a simple example that USPTO uses. If you look at this gunpowder comprising, for example, potassium, nitrite, charcoal, and sulfur, each of these elements is naturally occurring. It recites the judicial exception, right? But once these are combined, it becomes gunpowder. If it's not combined together, it's not gunpowder, right? So by combining, it changed the characteristic of the sulfur characteristic of charcoal, right? So it satisfied the first prong in that it includes the naturally occurring product, but it does something more than that. It changed the characteristic. Then it becomes that this claim is not directed to judicial exception, even though they recite the naturally occurring product. So that's one way to get your patent. This is a very good example from the USPTO. I'm not going to comment whether the US examiner actually reads this or not, because I'm YouTubing right now. So, but you have to use this against the examiners if they refuse to give you the patent in many ways. So, number 1, there is such thing, it's an imaginary compound that they made up. There is amazonic acid in Amazon that they purify. Just by purification, it doesn't become patent eligible, just like the myriad case. But if you change the structure of it, make it 5-methyl, then it becomes patentable. And then, if you make the amazonic acid a core of a tablet, for example, like you cover it with the polymeric material so that the degradation in vivo changes, then it's changing the characteristic of the release in vivo, and thus it becomes eligible. And then, if you mix the amazonic acid with solubilizing agent and increase its solubility, then it changes the characteristic, and thus you can patent it. And then, if you use the amazonic acid to treat a specific disease, it becomes patentable subject matter. So do you see how you can overcome the rejection and how you can get the patent by changing the additional elements, right? And as I mentioned, amazonic acid can be used to treat a specific disease and it becomes patentable, right? And the famous case is Vanda pharmaceutical case from 2018. A naturally occurring product was used to treat a specific disease, and now it became an integration of a naturally occurring product, and thus it became patentable. And based on the Vanda case, there have been several cases, district court cases, that have determined that the method of treating is now patentable. Okay, it has to be. The most difficulty that we have in obtaining a patent because of this patentable subject matter is diagnostic. So as you may have heard, and the previous case that I mentioned, which one was it? Sorry, Mayo. So Mayo is the one that's using the law of nature, right? So you have discovered that cancer can be detected by a particular marker. But the correlation between the marker and cancer is just law of nature. But you made a great invention. Like, it's amazing that you found that marker. But it would be hard to patent it because it's law of nature. So method of diagnosing has been very, very difficult to obtain a patent. So we changed the method of diagnosing to method of treatment so that it doesn't become directed to law of nature. But the most sad part is that once you change it to the method of treatment, think about it, the people who are treating are either doctors or patients. So they are not the companies that make those markers or companies that diagnose. So it would be indirect infringement instead of direct infringement because you don't want to sue the doctors or the patients. You want to sue the companies that make the probes or do the diagnosing, right? So a lot of clients don't want to change the method of diagnosing to method of treatment, and we try our best, but sometimes there is no choice but to do the method of treatment. One way to overcome it is to make it a method of preparation instead of method of diagnosing. So this case from 2020, this was very smart. They claimed method of preparing a sample, basically. This is a diagnosing case. This is a diagnosing case, but they wrote it as if it's method of preparing the sample, and they detailed how they prepared the sample, and they were able to make this patent eligible. So when it's method of diagnosing, you want to pretend as if it's not method of diagnosing. And when we try to do that in the US, the most difficulty we have is that a lot of applications that come from Korea, for example, do not have original disclosure for us to use to make it look like non-method of diagnosing claim. So please make sure that when you file something in Korea, make sure that you have enough disclosure to make it look like it's not method of diagnosing. And for example, method of preparing a sample or method of treating, you need to have enough original disclosure so that when you come to US, you'll be able to get a patent. I have seen a lot of cases that we had to abandon because there's no way to get a patent method of diagnosing, so which is that. So again, the method of diagnosing is very difficult to obtain a patent in US, but I think it's only in US again. No other countries, only in US. I am not going to comment more. And the second way to show the integration to prove that your claims are not directed to judicial exception is to show technical improvement. This method is used a lot in electrical cases, software cases. A lot of the cases that USPTO examiners have determined to be abstract idea, if you show technical improvement, like improvement in the function of computer or improvement of computer memory system, you can use it as an evidence that it's an integration of an abstract idea. So we, even though I know today's focus is biotech, we do a lot of digital therapy, and there's no way that you avoid AI now, right? When you use AI in biotech, you have to think about the abstract idea, and you have to think about how to obtain a patent using the AI or pretending like you're not using AI. So this EnFish case was a data storage and retrieval system, including means for configuring set memory and means for indexing data. Although the examiner, USPTO, has determined that it recites the abstract idea, it is not directed to the abstract idea because it showed the integration of the abstract idea by improving the computer capability. I'm going to admit I'm not electrical engineering background or software background, but the point is that in the specification, you need to show what type of improvements that you have made using your technology. And I think you're going to get this slide after the presentation, so please take a look at it. When you get bored, you can look at all the examples you want. So I have added the examples of successful cases, successfully patentable cases here. So when we obtain a patent from the US Patent Office, we try to copy these cases, we try to copy these claims that are determined to be patentable by the Federal Circuit and use it against the USPTO to obtain the patent. So the third step, and I swear, 2 more minutes. So the third step, so you have determined that your claim is one of those 4 statutory categories, and but your claim is directed to judicial exception. Then is that the end of it? No, there is one more hope. Even if your claim is directed to law of nature, if you can show that your claim recites additional element that amounts to significantly more than judicial exception, you can still get a patent. And this is what Mayo Supreme Court decision was talking about. So the additional elements, other than the judicial exception element, has to be more than something known. Like it has to be significantly more. And you're like, what does this mean? So this third step, in my opinion, is the most difficult one. Like this is an interesting case from 2015. This is about detecting father's DNA from blood from pregnant mother. So like when I was pregnant, my kid's DNA was floating in my blood, and thus my husband's DNA was in my blood. So nowadays, by getting the blood from pregnant mother, you can detect like DNA of the father of the baby, which is like amazing, right? I mean, it has been known for a long time that there is a small amount of your husband's DNA in the pregnant woman's blood, but it was never able to be detected. So this company was the first one to detect it, which is amazing, right? Amazing. But Supreme Court said it's not significantly more. The people who have decided to make this decision were not women. Oh, sorry, I should not have said that. But I thought this was like amazing. But so what I'm trying to say is that what is significantly more, in my opinion, is very subjective. So you have to be able to persuade the examiner or the court that your additional elements are significantly more. Like think about it, I never knew that my husband's DNA was floating in my blood when I was pregnant, which is like yucky. Oh, I hope my husband's not watching this YouTube. So anyway, so what is something more is very subjective in my opinion, but I have listed a lot of the examples that the courts have decided that there are something significant more in here. So you can take a look at it, and basically what we do is we try to copy the arguments that they made in these Federal Circuit cases that successfully have determined that claims are patentable. So this is another case that was interesting. It was a method of diagnosing. We had high hopes about this case maybe patentable, but the Federal Circuit case said no. And what was interesting about this was that it was method of diagnosing, including detecting, and it was determined to be not patentable. But this was totally in contradictory with the USPTO guideline. Because in the example of guideline, it says that method of detecting is patentable as long as it doesn't recite diagnosing. So maybe reciting of diagnosing was a wrong move. But in any case, if you have a diagnosing case, you want to pretend as if you're not diagnosing if you want a patent in US. So again, do not, pretend to be not diagnosing, pretend to be not AI, pretend to be not naturally occurring phenomena or law of nature. So pretending is very important. So I'm going to cut it here, And do you have any questions about the presentation? No? Afterwards is fine too. Anytime, please let me know. So my email is janice.logan@morganlewis.com. Pretty easy, so please send me an email anytime if you have any questions. So I came to US when I was 16, and I went to college for materials engineering, PhD at Hopkins, yay, Hopkins, for biomedical engineering. The reason why I went to PhD in biomedical engineering was because my boyfriend at the time decided to move to DC, so I had to, and it was the best college around here. But it ended up to be great because no one from materials engineering came to biomedical engineering. And when I was in materials engineering, I did polymer concentration. And I learned a lot about the electrical material and magnetic material, which helps me do more medical device cases right now. And I think it ended up to be great. And as you know, bio these days include everything. Electrical, mechanical, AI, everything. So I think it was very appropriate now I think about it. I do appreciate my ex-boyfriend. When I was in PhD, I decided I'm not well suited for a researcher because I didn't have any great ideas. I think everything that I have researched on and everything that I have thought about would have been determined to be obvious under the patent standard. So I didn't have the bright minds as some of my friends did. So I decided I would go out of the research and help those people who actually have the great ideas. And that's why I went to law school right away. And while I go to, and I became a patent agent in US. Becoming a patent agent in US is very easy. You just need to study very, very hard for a week. Any PhDs can, in my opinion, anyone who has PhD can study very hard for 1 week and you will get patent agent exam passed. And then you can work as a patent agent in a law firm, which I did, and went to law school at night at Georgetown. So as you know, Georgetown is the #1 part-time program in the US. So you are in the great location. And I think #2 is George Washington. So the top 10 part-time programs are all located in DC area. So I do most of it. So I do recommend working as a patent agent and going to night program if you're in DC. And then it's also good for job security. I remember like my first semester, I was like telling my boss, oh look, I got all A's, didn't I do a good job? My boss said, Janice, this just means that you haven't been working hard enough. So once you have a job in a law firm, as a biotech PhD, it's very hard to be fired because there are few of us, there are very few of us. So job security is great. So if you have PhD, I do recommend getting the patent agent exam done, and the law firms pay for your law school too, which my parents do appreciate. So I highly recommend that. If you have any questions, please let me know. I'll be around, and I think that's it. Okay, thank you. Have a good day.
So what are we talking about today is something that I mentioned a little bit different, and give you that aspect of some of the things that you can do, another thing you can do with your degrees in science and engineering. We've had some very good examples of working as patent attorneys. I want to talk a little bit about other types of careers, and that's in technology transfer and business development. And for those of you who may not know what technology transfer is, it's the process of transferring discoveries from the research enterprise, such as NIH or universities, creating universities, for example, and getting information, that technology over to commercial development. Basically, by doing that, we were facilitating the development of these new ideas and new technologies so they actually reach the public. Because the public is not reading the scientific papers, the public is not reading the patent literature, but the public really benefits from the actual physical product, and that's what we're trying to facilitate. So another way to think about it is that it's kind of a mix. So it's a mix of science, it's a business, and law. So it's patent law, course, science, as we know, scientists is constantly changing. So, and one thing I'd like to have you think about is maybe as a scientist or engineer, you're already doing technology transfer and you didn't realize it. If you think about this chart, we start from the left-hand side with the research outputs, things that we do in the laboratory in terms of publications, creating new materials, new know-how, innovation, and learning new skills in laboratory. Well, that's the start. But you can see it goes through what we call KE channels, or knowledge exchange channels. And that's in teaching, consultancy, professional development, research collaborations, licensing, in terms of very active product transfers. That's the channel. And there's a number of users that utilize this. And these are places such as startup companies, whether they're in the US or in Korea, or other types of society, government offices, entrepreneurs, big companies, small companies, all people that are using these ideas, and the impact that sometimes we like to sort of know about in terms of governments or officials, is that what happens? Is it job creation, new products, new services, sales, profits, all this economic activity and changing sort of innovation. So this is all part of it. So the aspect then of this is that in terms of technology transfer, it's sharing discoveries, sharing in terms of academics, or transferring that to the companies for development. That can be cell lines, software, databases, applications. We're also working to facilitate collaborations. There's always more work to do. The initial discovery in the laboratory is just the start, of course. We don't always realize in the lab we think we've found everything, but it's really just the start. And then, of course, to protect that, we work very closely with our patent attorneys to manage our patent portfolios, manage the work that the patent attorneys are doing, and try to do license agreements for development. And it goes to the commercial development of the idea. Those can be to existing companies or be the basis of startup companies. So there's a whole range of activities we're working with startups, small companies, large companies in terms of the development. So for scientists, though, where does this fit in? When you think about technology transfer, it's putting the overall global goals of what we have as both research institutions, as hospitals, as government agencies, as state economic development. And these are often, we share these humanitarian objectives, whether we're working in a hospital, a research laboratory, in healthcare, or a pharmaceutical company, we have these humanitarian objectives. And the other thing we think about is really healthcare is global. The idea that healthcare can stop at the border. No, it's really kind of a global enterprise, and that's one of the aspects of technology transfer. Is that better? Yeah. It is a global enterprise, so we're working very closely with not just people in our backyard, but companies and universities and organizations throughout the world. For example, NIH, 25% of our agreements, of our license agreements, are with non-US companies, and we also have a number of agreements with Korean companies as well. But the other aspect is of economic development. And it's not just economic development, say, in the United States or in Korea. If you improve healthcare, you improve well-being, you're improving economic development in all areas of the world. And so that's a very strong basis for better understanding, more cooperation, and sort of improving the economies of companies and organizations throughout the world. So, this is my premise, what I'm talking about today. Is technology transfer, business development, a new career for you? And I'm going to say yes, I hope it is anyway. Life is possible after doing research. We've had two examples already of research scientists that ended up becoming patent attorneys. And so that's one of the questions really asked. Let me try. This one's a little bit better, right? Okay, that's good. My voice doesn't carry too well, but I have some static there. So let's think about how you can consider career in technology transfer business development. What are some of the activities in the job? How do you make the transition? And I'll talk a little about my story, the story from our speakers. I'll get mine as well. So the first thing, a very simple diagram. So technology transfer refer to interdisciplinary field. So we're kind of the bridge. So you would have a scientific discovery from our research laboratories, our engineering research scientists, and you have commercialization at the companies. So intellectual property, patents, technology transfer, that's really the bridge. Let's work together. Another way to look at it, particularly in the healthcare area, would be sort of think of a continuum for drug development. We start on one side here with scientific discovery. We go through intellectual property to protect that discovery. We have technology transfer to transfer that discovery. And we have financial capital, corporate partnerships, research and development, clinical trials, regulatory, manufacturing, and then sales and marketing. So one way to think about that is that the technology transfer and business development, that's a process. So if you have a scientific or engineering degree, any one of those green dots is a career opportunity for you. So you may not realize that in graduate school. I certainly didn't know about this. But there really is a lot more that you can do if you want to leave academia and broaden your horizons. So what are some of the characteristics? How do you get started? Well, there's two things. One is the scientific basis. And well, you have that sort of background in terms of the science or engineering. You have that. What we're often missing is sometimes the business aspect. And that's something that we can acquire. That's something like, or if it's a legal background, that's something that we can acquire going to night school, for example. This is a good example. I went to night school in an MBA program, so I know how these things work. But the thing is that you need to set sort of think about your career goal and then set a slow pathway. It's a marathon. It's going to take you 26.2 miles to finish because you're working, you have family, you're going to night school. But it's a realistic thing that you can do for our speakers and myself. You can see it's possible to get that done. So taking another look at it, so who all participates in the technology transfer process? There's a lot of people. It's not just the three of us here this evening who participate in the process. You know, we have scientists who's part of the discovery process. We have attorneys, patent examiners, patent agents, licensing, entrepreneurs, business development, economic development people from our state and national government. So all these people are part of the technology transfer process. So how does this all work? Let's do the example maybe of technology transfer, let's say you're at a university or a federal lab. So here, if you're a technology transfer professional in those areas, you're evaluating the inventions for patenting. So you're looking at sort of marketability, business opportunity, and also you're doing some initial review, probably with your patent attorney, to sort of, is it patentable? So you're evaluating. You're not doing a scientific review. You're not criticizing your scientists on their science. You're reviewing it for marketability and profitability. But you're still working very closely with those scientists and those inventors. And then often we'll work and places work with outside law firms to help manage the portfolio. We talked about patenting in the U.S. We talked about tonight patenting outside of the U.S. See, it's a very complicated process, and using those skill sets and those services is a very important part of the process. What we tend to focus on is let's find the partner, the business partner for that. So you're very active in marketing. You're trying to identify who's the partner for collaboration, who's the partner that can take your idea to a further development. Because you don't want to just have it sit in the laboratory. You just don't want to have it be a scientific publication that's in the library. You want your idea to actually go forward, become a physical product, and have big important impact on the world. And of course, then, as part of this process, we're managing the relationship with our corporate partners. So when you think about this, you know, you talked about 20 years of patent term. Well, that's almost like, that's a long relationship. So we have to think about this in that long relationship when you manage your relationship with your corporate partners. So that's with universities and federal labs. What about if you're at a small biotech company? how does that work? Well, small biotech companies, you're at the focus of the action, because the intellectual property is really the major asset for a small biotech company. They in-license ideas from universities and research institutes, and then out-license after they've done development with the larger partners in the biotech area to pharma companies. So if you're at this firm, you're involved with corporate management. You're involved with management. You're involved with everything. Remember, it's a small company, so you get to wear many hats in terms of the activity. In terms of entrepreneurship, once you've done one of these and you see how it works, it's very possible that you would be able to start your own company. So often what we see is that scientists will transition to small companies, learn how it works, and then they will leave a small company and then start another company. So it's very entrepreneurial that way. What about business development of large companies? It's a little different there. There you're a member of a group, so there's plenty of other assets rather than just intellectual property, but you specialize in a particular area. You know, oncology, biotech, you're specializing in everything that they're doing. And a pharma company is going to be usually a particular area that they're focused in. They do a lot of deals in that area, like maybe oncology, maybe vaccines. So it's more in-licensing than out-licensing. They bring things in at a more mature level. If it doesn't work for them, chances are it's not going to work for anyone, and they usually let it go. But a lot of in-licensing activity as a career, historically it's been more stable. Biotechs may have a short lifetime. Pharma companies used to have a longer period of time. There's been a lot of consolidation in most companies as well. Things are more stable, it's managed at a slower pace, it's a larger company, a larger organization. So what kind of background do you need in terms of education? Well, you need a degree in science or engineering, a PhD, a master's, bachelor's. I put down patent agent. I'm also a patent agent. I took the test. I think I spent longer than a week, but not much longer than a week, probably. You can have an MBA, you can do a law school. So it's usually, you don't need all of these, but some kind of mix, some sort of blend. Usually a science and technical degree, and then maybe a little bit of something else. So what are the skill sets that you need? Well, the skill sets we talked about, the work ethic. You're going to school at night with a family, and you're working. You have the work ethic, so there's no question about that. And also think about your potential for development. Where are you going with this? You're not just going to school to get another degree, even if somebody else is paying for it. You're looking for your own sort of satisfaction, your own intellectual curiosity, your own sort of long-term career development. Think about where you'd like to go and who you'd like to be. Talk to different people in those fields. So skills, again, expertise in something in the way of science, law, or business. You have to learn the relevant aspects of the other parts. Remember, it's a three-sided triangle. You probably came in on one side of the triangle, but you need to know the other two sides. Really, it's about communication. It's really, remember, you're a facilitator, you're a bridge between science and business. So you've got to be able to talk business, and also have to be able to talk science. Now, you're not going to be the same as someone who is only in science, only in business, but you're going to be a translator, a facilitator. We're focused on teamwork because so many people have to work on these projects together. And others have mentioned it's really about time management, project management, because typically there'll be many things you could spend your time on. What are the things that are most important? What's going to really help move the project along for development? So think about that. So we have a equation here. We can't have a scientific talk, but at least some math here. I've been told by the organizers that yes, it's will be on the test. So this is the algorithm that a colleague of mine put together for success. So you have C is your career success. So you start with your achievements, things you've already done. potential, the things that you could be doing or should be doing, add those together, you multiply it by visibility, which of course why you're here tonight, is to meet some other people, get some different ideas, some visibility to yourself. And then you also multiply by luck, because maybe it's luck you were here, otherwise you could have gone home and watched the baseball game or something instead of TV. Or you might bump into the right person at a meeting or a conference. So there's a lot of luck, but it's often luck that you make for yourself by your visibility and your achievement and potential. So here's what you need to do. How to conduct your search. Networking, I put this number one. It really is important. And as sometimes as scientists, we tend to only talk to other scientists in our group. As scientists, sometimes we and 6 other people are the world's experts on something about this why. Very, very knowledgeable, but very deep. So this is something that's flipped. So you're about an inch deep, but you're miles wide because you're more of a generalist. It's a very important part. Think about your self-image, your communication skills again, know what you're looking for, and circulate. Circulate your CV, your interests, your business card, networking in the room, that type of thing. So how can you get more information about technology transfer? Well, NIH has some tech transfer fellowships. So NIH is probably famous for having scientific fellowships. So these are fellowships where you get paid, but you're not working in the lab, you're working in the tech transfer office. So we have 3 institutes that have these programs. Or you could do maybe internships at universities. The 3 main associations are Association of Technology Managers in terms of meetings and education, Licensing Executive Society, which has a DC chapter, and the Federal Laboratory Consortium. We have online courses there as well as meetings. So my own career story is that I was in graduate school in chemistry at the University of Cincinnati. In this case, it was my girlfriend who got into medical school at U of Washington. So I left my PhD program and moved to DC. My story's turned out a little bit better. We've been married now for 46 years. However, the job that I took when I was moving to DC, I did not like. I actually worked at the National Cancer Institute. Was not happy, mismatch. So my transition out of the lab was a bit through business in terms of sales and marketing role in lab reagents. I started as a sales representative. Then I became a product manager for electrophoresis for another Swedish company. So, and I did go back to school, but not for my PhD in chemistry or biology and MBA in marketing. And so I held jobs at universities and small companies, and I came back to NIH in 1990. So I didn't like it. NIH in the 1970s. The 90s was much better. Thank you very much. Okay. So here's the educational programs you should be thinking about: the Tech Transfer Society, the Federal Lab Consortium, on the LES, and give you a little bit of detail about some of our fellowship programs. Is that the one at NCI is the largest and most well known, and it's a 1-year appointment with additional opportunities up to total 2 years. It's going to be 5 years. It's rare that anyone lasts that long, because usually after 1 or 2 years you get hired by somebody else. You transition out quickly. And it's similar to the postdoc salary, so you don't want to stay too long in terms of that, but our pay to learn tech transfer rather than laboratory techniques. So what's required? Again, advanced degree, bachelor's or master's in public health, science, or law, business in the past 8 years, so it tends to be younger people. Communication skills, and interest in tech transfer. What's interesting is applications for all these fellowships are kind of year-round. They're not really federal positions, they're really fellowship positions, and when there's an opening, we fill it, and then the next time there's an opening comes, around. So here's an example of someone who inside postdoc to a VC merchant banking firm, and later became a CEO of Cancer Center. So again, thinking about this as a career is challenging. A lot of variety, very dynamic. Just some examples are here. Lots of things are happening. There's still a demand for skilled people, both in the U.S. and also with such that there's interest in Korea. You can work in universities. You can work in government labs, not-for-profit research institutes, corporations, patent law firms. There's a lot of variety of things you could do with your science and engineering degree that you didn't think about. I never thought about any of that when I was in grad school. And it's an opportunity I can say. So here's some websites you could be thinking about to find some more information. I'm going to talk to you. And of course, Uncle Sam does want you to do more tech transfer. So thank you very much.